Good afternoon. My name is Barney O'Dan. It's a great pleasure to be with you for the next hour. I'm just looking at people subscribing, and I'm amazed at the global reach of the audience. And congratulations to the association for being able to put people together at this particular level. Welcome to this webinar brought to you by the International Association of Young Lawyers. It's the only organization that at a global level looks after the interests of young lawyers, particularly those under the age of 45. And what it does, it provides outstanding on and offline opportunities for you to network, to learn, and to grow both personally and in your individual practices. I am from Vlerick Business School, which is the #1 business school in Benelux, rated by Financial Times as top 15 in Europe and also one of the top 100 worldwide. We are based in Ghent at the moment, but we also have campuses in Brussels, Leuven, and in China too, as well as a presence in Russia. My own background, very briefly. Like you, I'm a lawyer by training. I taught and practiced law for many years. For many years also ran a consulting practice focusing on negotiation, on dispute resolution, mediation, while teaching at several business schools as well. So I became a bit of a pracademic for a while. For about the last 2.5 to almost 3 years, I'm back in an academic role at Vlerick Business School, originally based in South Africa, but now based in Belgium for the foreseeable future, for the next few years. And my focus here is really in terms of teaching and research and publications is in the area of negotiation, dispute resolution, and mediation has a strong focus in this as well. I've authored a number of books, book chapters, several articles in a broad range of disciplines in the area of law. Anybody who's interested is welcome to get in touch with me. If anything I say today is of interest to you and I've published anything in that particular area, I'm happy to share that with you. At the end of the presentation, I've given you a bibliography with references to articles that I've used in preparation for today, and those are available online. But if there are any that you are particularly interested in that I can send to you, I would be more than happy to do that. So, what are we going to cover today? I'm stating the obvious if I say that, like the rest of society, the legal world is undergoing dramatic change as well. You face many, many challenges. We'll talk about some of those, where do those come from, and what are the particular challenges for you, but also what are the opportunities that these challenges provide for you. With every challenge always goes an opportunity, and I'm going to try and help you spot an opportunity, one particular opportunity that might make you, as a lawyer, more diverse in your service offering to your clients as a problem solver. And as you'll see from the presentation, that involves multiple roles that you as legally trained people can fulfill. We will also look at what do your clients actually want? What do the users of dispute resolution services actually want? We've done research in this area, and it was quite striking that there's a gap between what users, your clients, want, what you think they want, and what they get provided with by providers like mediators, arbitrators, judges. There's a gap there. It's a gap that is worth taking note of, but it's a gap that you are able to fill if you do certain things correctly. What constitutes justice? You became a lawyer in pursuit of justice, of course in pursuit of decent fee earnings as well, but your primary objective was justice. But is there only one form of justice? Is access to courts the same as access to justice? Or are these two different concepts? And maybe we can conceptualize justice differently, and if we can do that, it opens up many, many possible opportunities for you as lawyers to provide justice, if not through the courts, then through other dispute resolution processes. What if we looked at your clients at the users of dispute resolution services as consumers? What are their needs? And how can you fill those needs? And how can you reinvent yourself? So those are some of the issues we're going to address. Although time is limited, I'll allow as much time as I can for questions and for interaction, so feel free to post your questions as we go along. Let me start with a puzzle. Now, this is an old story about a man who lived in the Sahara deserts. in a traditional environment. He was lying in his deathbed. He had 17 camels, which he now had to distribute between his 3 sons. And in terms of custom, only sons could inherit. Now the dilemma is 3 sons, 17 camels. He's not allowed, in terms of this custom, to deviate from this formula. He's also obliged to ensure that the camels are bequeathed to his descendants alive. So they can't be cut in half, they can't be slaughtered. They have to go across to the heirs as they are. So how do you solve this puzzle? Because custom says that the oldest son must get half the camels, half of 17. The youngest must get, the middle one must get a third of the camels, and the youngest one must get a ninth. So if you were asked to give advice to this particular person about how to distribute the camels, what would your legal advice be? Are you able to provide solid legal advice with this particular conundrum? Any thoughts? What would your advice be about the division of this gentleman's estate? All right, nothing forthcoming yet because it is a puzzle that cannot be resolved by law. There we go. It's a puzzle that you cannot resolve legally. And that's often the case, that we have a particular problem which has a deeper dimension than just a legal dimension. There's a business dimension, there's an interpersonal dimension, there's a psychological, emotional dimension that we cannot put into a legal framework. But we are trained to do just that, to take that problem and to put it into a legal framework to get a legal answer. And very often the law gives you an answer, but it doesn't solve the problem. It might even go as far as resolving this particular dispute, but the underlying conflict is not yet resolved. Dan Mahai says, choose in order by youngest, mid, and least the older. Well, that's a possibility, but your problem is still that you have a formula that is going to result in a division that leaves you with part of a camel and not a full camel. Well, what happened in this particular case, this gentleman was quite wise, and he said, look, we cannot resolve this. I only have 17 camels. I wish I had more, but I know that there's an old wise woman who lives in the desert a few miles from here. I will send one of my sons to go and call her, to bring her here so that we can converse and she can guide us with her wisdom to find a solution. So along she comes a few days later through the desert with her camel in tow. She enters the tent, camel is parked outside, she listens to the conundrum, and then she says, here is the solution. What is the solution? Well, very simply, she added her camel, which makes it 18. Then she does the division. So the oldest one gets 9, the middle one gets 6, the youngest gets 2. That's 17. And she goes home taking her own camel with her. So, okay, of course, there's a little trickery involved here. But the point of this exercise is that very often legal dispute resolution processes do not give your clients real answers to the problems that they sit with. Sometimes law does that. Often it does not. And that is where, as a problem solver, you may be able to serve your client better by saying, look, maybe this problem cannot be solved legally, but we've got a range of other options here that can help us solve this particular problem in a way that meets the client's particular needs. Now let me start with the current environment in which you find yourselves. You might have heard of this term. It's already a bit tired in use, but it's the VUCA world. It's something that was developed by the military, the American military after the fall of the Berlin Wall, when the entire global security or safety scene changed. Previously, there were very clear enemies. There was the Soviet Union, there was the West, and there was the East and the West, clearly divided between the so-called good and evil, depending on which side you were on. We know who the enemy was. And suddenly the Berlin Wall fell and a whole range of other changes happened. And nowadays, warfare is no longer a predictable thing. The enemy is no longer easily identifiable. So the military started saying, we live in a VUCA world. It's a world that is volatile, that is uncertain, that is complex and ambiguous. And we need to change our strategy, our war strategies to cope with this new world. But this is a concept that we also apply in the business world, including the legal business world. There are so many things happening in the broader environment that affect your practice and the way you practice law that you often don't have solutions for. So the only thing one can say with certainty is that all of you probably experience this turbulence, this uncertainty. Will my practice survive? Will I still have a job? What will happen to legal services? Where does law fit in? How can law reinvent itself? How can I meet my clients' increasing demands? They're asking me for faster, better service delivery at lower cost. How can I meet those challenges? Now, this is unfortunately something that we all experience, both personally, but especially in a business environment, and you as well in your legal practices. So, how does this affect your world? How does this affect your legal environment that you work in? Any ideas? What are the kinds of impacts that this VUCA world, this volatile environment, have for you? What are the concerns that you have arising from this volatile, uncertain environment in which you practice law? Any ideas? Any ideas? See, Sven is typing. Legal tech, absolutely. Technology is emerging. There's a startup in Palo Alto, started by a young Belgian lawyer, that is going to provide legal services on an eBay basis. So a client would come and say, I have a problem. That problem would then be put out to the legal market globally and say, what can you offer by way of services, and what bid do you have? What is the fee you will charge? So legal services might be auctioned off. Online dispute resolution. There are a variety of technology-driven solutions coming forward, of course, that potentially pose problems for you. Okay, Elena, I think you've got a problem with a window and a speaker. I hope you can sort that out. All right, it all works now. I'm happy. But these are some of the changes that emerge. But let me just start off by giving you this quote from a book that, if you haven't read it, it really is worth reading, by Richard Susskind. It's called Tomorrow's Lawyers: An Introduction to Your Future. It is aimed particularly at younger lawyers. He says, tomorrow's legal world bears little resemblance to that of the past. Legal institutions and lawyers are at a crossroads and are poised to change more radically over the next 2 decades than they have over the last 2 centuries. If you are a young lawyer, this revolution will happen on your watch. He also wrote an older book, 2010, I think, called The End of Lawyers, which is also worth a read. So what are the key factors driving this change? Deregulation of the legal market. Other people are doing your work. Accountants are doing your work. Other people will start doing legal process work, routine work, taking that work away from legal firms. Disruptive technologies. Have a look at Square Trade and LegalZoom. Square Trade is the online dispute resolution partner for eBay. They handled something like 16 million disputes a year. Churning out a lot of money in the process, but they can offer very quick, very cheap dispute resolution services. Have a look at LegalZoom as well. The vanishing trial. You get trained as a lawyer, you're raring to go, you want to get to court and present your client's case, only to realize that only a small portion of cases ever make it to trial. What does it mean for you as a lawyer? If you're not going to end up in trial in 95% of the cases, what are you doing? How do you then make yourself more useful to your clients? If there's no trial, what are the other options to find a way to resolve these disputes in a way that meets the client's needs, but at least gives you a decent turnover and profit as well? Increasingly, legal cases are on the increase. They don't decrease, but increasingly people can't pay. So either justice is not being served and done, or people are finding other ways to find a solution to their problem without engaging you as counsel. And then, of course, the changing needs of counsel. I work with of clients. I work with a number of large corporates, and I know what they're doing, and you probably have experienced as well. They're looking at ways to cut legal costs by looking at things like early dispute resolution, trying to resolve it in-house as quickly as possible by direct engagement with their counterpart, by using mediation, by very carefully looking at every case and making a very rational and clear decision about whether to litigate or whether to use other forms of dispute settlement. Because what they want is they want solutions that are faster. They can't wait forever for a solution. It has to be cheaper, and it has to give them a better solution than they can often find in the court. So those are some of the changes that you might be experiencing at the moment. Okay? We did a survey on changing client needs, and I'll show you some of the results, and it's quite illuminating to see the gap between what lawyers often in general provide to their clients, what service providers like courts and arbitrators and mediators provide to clients, and what the client's actual needs are. There's a gap that you need to be aware of, and as I said earlier, that you might be able to fill as lawyers. But let me start with a quote that I find quite illuminating from Mr. Berenson. He was the General Counsel for General Electric, Global Legal Counsel, and this is something that you can Google. I have it in the bibliography as well, but it's the Singapore Mediation Lecture of, I think, 2015, where he talked about GE's dispute resolution policy. And GE is a world leader as far as dispute resolution processes, dispute systems design is concerned. And this is what he says about businesses' needs. He says, winning cases is not the same as winning in business. Prolonged and costly disputes that disrupt business relationships and create bad public relations detract directly from a company's bottom line results, even if the litigation ultimately results in what the lawyers handling it would regard as a successful outcome. Successful businesses want disputes resolved as quickly as possible with reasonable outcomes so the business can avoid wasting money on unproductive conflict, preserve and grow valuable business relationships, minimize reputational risk, and keep its employees and resources focused on innovation, customers, and winning in the marketplace. That is a very, very strong message to lawyers about the needs of clients. Jovan has also indicated that one of the other main disruptors for the legal world, of course, is artificial intelligence. And if you look at Richard Susskind's book On the End of Lawyers, that's pretty much part of his focus there as well. So those are things I think that you need to be aware of that initially come across as scary, but the mindset should be, how can we profit from this? How can we, as lawyers, given our training and perhaps some further learning development, actually meet these challenges and turn it to our best advantage? And this is a quote from a recent report, the survey on dispute-wise business management, focusing particularly on France. French companies increasingly view the effects of disputes as a strategic consideration with potential impacts on corporate policy, financial results, and brand image. So what they're really saying is we want our lawyers to work with us, case by case, to identify the best process with which to resolve this particular case. And then they say the kinds of considerations that we want to take into account obviously is cost, time, but risk to the business, including reputational risk. And also, just generally speaking, our reputation. All of those factors go into their choice of dispute resolution process. And this is what we found in our own survey that we conducted here among lawyers, both in-house and external lawyers, as well as users, corporate users of dispute resolution services. Clients focus on risk management, efficiency, in other words, getting it done as quickly and as cheaply and effectively as possible, getting good solutions to their problems, in other words, and maintaining business relationships wherever required and wherever possible. We realize that legal advisors, in-house and external, are not always in tune with clients' needs. They often think clients want a legal answer. They want their case to be heard, and that is often not the thing. They have a business solution in mind, not necessarily a legal solution. And then the scary result was that advisors, like yourselves possibly, are not always aware of the multitude of dispute resolution options that are available to you and your clients. And if you're not aware of it, there's no way you can advise your clients about what would be the best process for them. And the research tells us that the clients look to you for guidance. And it's your duty, in other words, to acquaint yourself with all the available options so you can provide the client with better service. And then, interestingly also, clients say, we would prefer to have even mixed options. In other words, that you have a situation where we go to negotiation first to try and resolve the issue. If we can't solve it, then we separate the business case from the legal case. If there are legal issues that must be resolved, in other words, we have to get a legal answer to in this case, well, let's design a process that will give us the legal answer quickly. It could be expedited arbitration, while we also farm out the business case, the dispute about the business issues, to mediation, so we can get a result on both sides. So they're looking at those kinds of options as well. You might also want to have a look at the results that we've gathered through a series that I'm involved in, the so-called Global Pound Conference series of the International Mediation Institute. There is the web reference, and you'll see we've covered various countries, jurisdictions, still a few to go, ending in London in July, where we would then, we've gathered a lot of data that also explores the gap between user needs and what they get provided with. Some of the data is already there, some of the results are already there, and it gives you a good indication of the extent to which your own practice is aligned with the needs of your clients. There's some questions here. If everyone puts their email, okay, sorry, this is between the various, yeah, this has nothing to do with the content. Let's see, okay. One consequence of this gap between your client needs and what they perceive they get from the legal world is the following. They get driven into the arms of alternative providers. The breakdown in alignment between buyer and supplier opens the door for new entrants ready to deploy an ever-increasing array of technological breakthroughs to solve a host of knotty legal problems. So this is the danger. And if you're not aware of what is available to your clients, if you're not aware of the technological tools you can use to assist your clients with various processes, you might just lose the initiative here as well. In the mind of the public, law, lawyers, and litigation are one and the same thing. So if clients have a bad experience with litigation, if they feel the law doesn't come to their aid, lawyers are blamed for that. So you've got to be aware of that fact. It's up to you to enhance your own reputation as a practitioner, to recognize when litigation, when the law is the most appropriate instrument for giving your client the best solution, and when it is not. And then to be able to step in as a problem solver, as we'll talk about, to actually fill the gap in your client's justice needs. Okay, but before I get to your potential role as a problem solver, I just wanted to take a step back to basics. Now, I wish I'd been taught this in law school. I never was. Maybe you have. But I never understood the structure of a dispute until I started practicing as a mediator many, many years ago. Because then I became aware of the fact that every dispute has 3 dimensions. And it actually doesn't matter whether this is a legal dispute or an interpersonal dispute at the office and the practice, or a dispute at home with your partner, with your children, or with a neighbor. There are always 3 dimensions involved. There's the problem, the substance, the merits, the issues. There's the process we use to resolve the problem, and then there's the people issues. The emotions, the communication, the mistrust. And it's obvious where law misses a very important point, or a few important points. Because as lawyers, we tend to define the problem very narrowly. We use a particular algorithm, which we'll come to, which actually focuses the problem on narrow legal and factual grounds. And as you'll see, what that does is it ignores a big part of the problem. Often it loses sight of the key problem, which might not be a legal issue. It might be a business or an interpersonal issue. As far as process is concerned, we often take off-the-shelf solutions. We say, well, okay, this is a case that has to go to litigation, this is the process, and we take it from there. We provide off-the-shelf solutions to sometimes very, very complex problems. But as you know, and as you'll see if you're not aware, there are a host of procedures available that could be used instead of and in addition to litigation to solve problems. And the one thing that we are certainly as lawyers never trained, or I never was, and I'm not aware of anybody who's currently being trained, is to be sensitive to the issues that often drive the conflict, the people-related issues, emotional issues, psychological issues, relational issues. Not only are we often unaware as lawyers, or we simply ignore the interpersonal aspects in the disputes we deal with, we ourselves are unaware of our own psychological makeup, of our own mindsets, of how our own training, our own backgrounds, our own culture, our own perspectives affect the advice we give to our clients. And there's a lot of research now being done around this, the psychology of dispute resolution, neuroscience, teaching us a lot more about our own inclinations as lawyers, which we should be aware of. Now, it seems easy to manage people-problem process. We say as a lawyer, you have to identify the correct problem, provide the right advice to your client about the most appropriate process to follow, and you have to be sensitive to any relational, interpersonal, psychological issues that might have to be addressed once the dispute has been resolved, because the relationship might be continuing, and even though the dispute is over, the conflict still persists. You might also have to be sensitive to any emotional blockages that prevent people from thinking straight about the issues. All of you have had clients who are so irrational, they don't see the real issues because they are stuck with certain emotional issues. What is your role there? You have a role to play, or at least you need to be aware of the fact that these blockages exist, and unless you can help the client deal with that, they will not think straight about the best rational solutions to the problem. So it seems easier said than done. But before I show you a clip to illustrate how difficult it is for the human brain to do this kind of multitasking, let me just take this comment from Evelyn. My experience is that my clients indeed want cheaper, faster, and better solutions, but are still very reluctant to try different forms of dispute resolution, such as, for example, mediation. I'm struggling on how to deal with that. May I ask you to shortly address this as well? Evelyn, certainly I will try my best to cover that, because that is a core, real question. In short, my own experience is that if your relationship with your client is a trusting one, if you are knowledgeable about the various process options, and if you can advise them about the pros and cons of each, that already can have a persuasive effect. But of course, your timing is also important. There comes a stage in any dispute, and if you pardon the expression, where people are still so pissed off that they're not ready for anything other than fighting. So it might take a bit of time. You might have to do a bit of anger management, help them get that frustration out so that they can think clearly about the longer term effect of what they're busy with. So do a little bit of reality checking. It helps also if you have some training and background in, for example, mediation or interest-based negotiation, where you can share your own experience and your own insights from that with your clients. And you might have to revisit this issue with your client all along the line. But I know it's a reality that sometimes you thinking clearly and you're thinking to yourself, this client is on a hiding to nothing, but they simply don't want to listen. They are in a process of self-destruction, which of course leaves you with a choice to say, okay, let me help you along in this path of self-destruction, or I'm going to pull out of this. So yes, you touch on a very important issue, and hopefully time permits us to go back to that. Evelyn, I'm in fact a lawyer and mediator as well, and still struggling. You might actually struggle more because you're a mediator, because you see the light and the client hasn't even started feeling the heat yet. But Evelyn, let me see if I can come back to that. But thanks very much for that question. So have a look at this clip. You might have seen it, but I think it so clearly demonstrates the limits of our own thinking. And hopefully it comes as a bit of a wake-up call for you as lawyers. So, but hang on, maybe we are not as observant as we think we are. So here goes.
The monkey business illusion. Count how many times the players wearing white pass the ball. The correct answer is 16 passes. Did you spot the gorilla? For people who haven't seen or heard about a video like this before, about half miss the gorilla. If you knew about the gorilla, you probably saw it, but did you notice the curtain changing color or the player on the black team leaving the game? Let's rewind and watch it again. Here comes the gorilla, and there goes a player, and the curtain is changing from red to gold. When you're looking for a gorilla, you often miss other unexpected events. And that's the monkey business illusion. Learn more about this illusion and the original gorilla experiment at theinvisiblegorilla.com.
Okay, so something to keep in mind is always say to yourself, I'm focused on the problem here, I'm focused on the legal issues, but maybe I must take a step back and ask myself, am I seeing the real problem? Am I looking deep enough? Are there only legal issues? Are there other issues involved? And what about process issues? And what about the interaction with my client, the emotional interaction, the level of trust with my client? And if I negotiate with the other side on behalf of my client, are we looking at the right problem? Are we negotiating process-wise in an effective way, in a win-win kind of way? We might not get a win-win result in the sense of equal happiness, but hopefully it's not equal misery. If we focus on a win-win process where we try to get the best for our client by also looking at what is best for the other side, then we might get a better solution. But we also have to be aware of the interaction and manage the relationship so that it can lead us to the best possible solution for our client. So keep that one in mind. I see some of you have already seen this. It's familiar to many of you. What do we do at the moment? What is the status quo as far as legal practice is concerned? I think we still work with this algorithm that a dispute plus failed negotiations equals adjudication. In other words, this has got to go to arbitration or litigation. I'm not saying this is always the case, but in my experience, that is often still the case. On top of that, then we can get to adjudication. We think that facts plus legal norms equals justice, objective justice. That is how we are often trained to think about the role of law. The focus is on fixing the past. It's on fixing the past or winning the past, not on creating a future. And the future might simply be getting this dispute resolved as quickly as possible so the parties can go their own merry ways, or fixing the dispute in a way that maintains the relationships that are important to maintain for both parties. But there are often other interests involved, and those of you who are familiar with mediation will know that in commercial disputes in particular, it's always about the money, but it is never only about the money. There are other concerns here: risk issues, cost issues, efficiency issues, relationship issues, reputation issues. It's time wasted, resources wasted, all for the sake of an uncertain outcome. We cannot guarantee the outcome, yet the client invests time, money, in a process they can't control for a result that they can't control either. That at best is 50-50. And on top of that, the vanishing trial means that the case is probably going to be settled in any event, and we've wasted all this time and effort for really very, very little. And if the attorneys, the lawyers at the end of that are also not good negotiators, just driving settlement, then of course it's the worst deal for a client. And then, of course, we often are not aware of the relationship concerns that might be important here in a particular dispute as well. So all of this happens for the sake of an uncertain outcome. Now, that is not efficient. And for me, the question is that really justice? It is sometimes a just outcome if the facts and the law and the outcome that provides is the best for my client. But we know that most of the time that is or should be the last resort. Can we get justice in a different way? And I'll come to that. As far as the problem dimension is concerned, let me just quickly deal with that. Those of you familiar with negotiation, integrative negotiations, interest-based negotiations, mediation will be familiar with this. As lawyers, we often look at the tip of the iceberg, the problem that is obvious, the problem that we can research and identify. But under the surface, it gets murky. And sometimes so murky that we really don't know what's going on. And that is often what drives the dispute. And that is where you can add value, to dig deeper into the source of the problem. Why are the parties in dispute? What are the concerns, the interests, the needs, the motivations driving this dispute? Can we craft solutions that will solve the deeper problem and perhaps also take care of the legal problem? The legal problem often becomes a proxy for a deeper problem that nobody looks at. But as a lawyer, we can help the client sometimes see the deeper problem, understand the deeper problem, and then help them find solutions that address the deeper problem and hopefully also takes care of the problem that we are trained to resolve, but often is just part of the problem and not the entire problem. So although the objective aspects of the dispute may be obvious to all of us, it's these hidden, the subjective aspects that actually drive the dispute, that remain hidden, and that remains to be discovered. As far as process is concerned, we give preference to power play. In negotiation, it's a power play. And if we have more power than the other side, well, that's great. But the problem is what we don't realize, if we have more power than the other side and we use our power to get what we want, we leave a victim. And the victim usually becomes the aggressor. And we see it. We see it in law. We see it in political arena. We see it in warfare. And as people with power, all we can control is the exercise of our power, not the consequences of that. Or we adopt rights-based approaches. We want to see who's right and who's wrong, instead of focusing, as I said, on the underlying concerns. So the processes that we adopt to help our clients should primarily, first of all, be aimed at finding out what are the interests of all concerned, and can we, through the chosen process, identify those interests, integrate them through creative thinking, creative solutions, as in the case of the camel. If that is not possible, then of course we have recourse to the law or to whatever coercive power mechanisms we have available. So the pyramid should be switched the other way. As far as the people dimension is concerned, it would be very advisable, useful for lawyers to actually dig into neuroscience a little bit more, into psychology of law. A lot is being written at the moment about that, to the neuroscience of law, how conflict impacts on the brain, and how we as lawyers often drive the conflict, not deliberately, but because we are unfamiliar with the psychology of conflict. You might have read the book by Daniel Kahneman, Thinking Fast and Slow. If you haven't, it's really a must read, not an easy holiday read, but it's a very, very solid piece of research that makes you look at yourself and other people very differently. Because what he essentially tells us is that so often what we do, what we think, is driven not by rational thinking, but by the rapid thinking system of System 1, where we act on instinct. And the danger is the more practiced you are in a particular area of law, for example, the more you are going to rely on your instinctive responses. I know what to do, and I'll do what I always do because it's worked before. The greater the chance that your gut feel might be wrong, that you don't pick up the different nuances in this particular case, and you make wrong decisions because of changing circumstances. Of course, System 1 does a lot of good. It keeps you alive, keeps you out of harm's way. It helps you make routine decisions without thinking. You drive a car without thinking, hopefully. But you make coffee without thinking, probably, unless it's really a special coffee that you're trying to brew. But so there's a lot of stuff we can do in a routine way. But the danger is that too much routine makes us lose sight of new information. And Kahneman says the tragedy of human beings is not that we are blind to the obvious, to new facts, new evidence, new changes. The tragedy is that we are blind to the fact that we are blind. So what we need to encourage is more system two thinking when we deal with a dispute. Each dispute is different. Each one has its own nuances. Yes, there are certain things we can do instinctively. We can fill in forms instinctively. We can do a whole lot of stuff instinctively. But each case deserves us putting on our thinking caps and say, what is the right dispute process here? What are the real issues here? What are the emotional and other interpersonal issues that are standing in the way of a sensible and wise solution here? And on top of this also, of course, is as lawyers, we think we are always rational, which may be the case, and wonderful if you are. Kahneman says it's not possible because system two is lazy and it's slow in its response. It prefers not to think. It prefers to rely on system one to make the decisions. But even if you're highly rational, the danger then is that you ignore some of system one's messages, especially emotional messages, your own emotions and the other side's emotions. Or you are not aware of the fact how your conduct impacts the behavior of others. How in an aggressive approach towards the other side, we actually drive them away from us instead of pulling them closer to us. There is, by the way, research that suggests by Samuel Gottman that 96% of conversations end with the same energy with which they started. 96% of the time, the conversation ends the way it started. So if you're going to come in there highly aggressive, chances are there's going to be no solution or everybody's going to be unhappy at the end of the day. So how I approach you in settlement discussions, how I approach my client to advise them to use a different process is absolutely key. That first move, the first words, the first proposal is absolutely key in sending a message to the brain of the other side. All right. Lawyers rely on intuitive cognitive mechanisms to evaluate cases, yet several cognitive illusions produce intuitions in lawyers that can induce them to postpone serious settlement negotiations or reject proposals that should be accepted. In this respect, they're no different from their clients. They take chances not worth taking. They spend time on information that's not relevant, yet ignore what is relevant, or they rely on information that confirm that litigation is the best way ahead, throwing good money after bad. I want to get to the gist of the presentation in the last few minutes that we have, and that is a potential alternative role for lawyers, an alternative frame, an alternative way of looking at law, at looking at justice. Psychologists tell us that if what we think, our mindsets, our mental models about law, about the problem, about process, about people, that affects our strategy. That in turn determines our behavior and gives us results. So if I see you as the enemy, the chances are that my strategy will be highly positional and adversarial and maybe even abrasive. And my behaviors will support that strategy. I'm not listening, I'm threatening, up the ante with more legal processes, more legal documents, and then maybe I win, but maybe my client still loses in the end of the day. Voltaire said, I was only ruined twice in my life. Once when I lost a case and once when I won a case. But if I change my frame and I say, this is a dispute where relationship issues are perhaps important for my client, where there are different process options, where the problem is deeper, where there are emotional issues that must also be addressed, my strategy is likely to be more collaborative, more problem solving. My behaviors will be more in line with that. Better listening, more creativity in looking at options, and perhaps I can get a result that's pretty good for my client, but hopefully pretty good for me as well. And even if I make a little bit less money because there's a quicker settlement, it enhances my reputation, which again might be a good brand building exercise for me. So what can we do as lawyers? Why should we change? Back to Richard Susskind, The End of Lawyers. I predict that lawyers who are unwilling to change their working practices and extend their range of services will, in the coming decade, struggle to survive. And we already see evidence of that. So this is an alternative algorithm that interests, the client's interests, not just financial, but all their interests, process interests, emotional interests, other substantive interests, business interests, plus agreed outcomes, amicable solutions equals just outcomes as well. In other words, there's justice through the courts, but there's other forms of justice too, designed by the clients themselves. Okay. Now, this doesn't mean that this is a lawless form of justice, because justice is derived not through the operation of law, but through party self-determination operating in the shadow of the law. In other words, the law is always a framework. You can't do deals that are against the law. But unless you break the law, there's so much scope for you to design a process that helps your client determine for themselves what is the best solution. It's not something that is enforced on them. It's something that they helped create as well. And now in this role, with this frame of justice in mind, the lawyer's role now becomes, on the one hand, a gladiator, a litigator if necessary, but also a problem solver who might find alternative ways of resolving the client's issue other than litigation. And these alternative ways do not only concern mediation. So what can you do as a lawyer? I've got 3 things that I want to suggest to you. Number 1, view your client as a consumer of dispute resolution services. And as a consumer, they have certain rights. And it's not just the right to justice. As a consumer, they have an entitlement to be informed about their dispute resolution options. And that means you have to be informed about those dispute resolution options. They are entitled to be provided with good advice about which ones to use in a particular case. It's horses for courses. Today we use this process, tomorrow we use that process. Or we'll start with this process. If that doesn't work, we have a fallback process that we can use. And they're entitled to quick, cost-effective resolution of their disputes with the least amount of risk. This is the client's list of entitlements as a user of dispute resolution service. So what we have to ask ourselves is, are we delivering on that? Because if we're not, they will find an alternative way of getting satisfaction. By using alternative providers, by using online technology, but they will find a solution. And that might not be in the typical legal practice that we are familiar with. Secondly, as a lawyer, you need to be aware, as I said, of the various dispute resolution options available to your client. Now, I've just listed broad categories, but you will know probably that this list is incredibly long, and it's getting longer as people discover new forms of dispute resolution. But there's negotiation, first of all. Lawyers, for most of the history of the practice of law until now probably, are not trained as negotiators. You are very lucky if you've had a course in negotiation at law school. You have to go out there and learn as you do it. You have to go and do additional courses. But this is a key skill. You negotiate all the time. And if it's not settlement, it's deal making. Or you're negotiating within your practice. But we are so poorly trained at negotiation. Yeah, we negotiate all the time, we say. But settlement is not necessarily good negotiation. So effective negotiation skills where we know which process to follow. Should we have a collaborative approach to negotiation here, or should we go in much firmer and harder? There's room for both, and we have to know when do we do what do we do first. There's early neutral evaluation, where we can refer disputes for early evaluation by an expert to get a sense of how good or bad our client's case is. There's mediation, there's conciliation, there's hybrids, arbitration and mediation combined, or mediation and arbitration combined, or med-arb-med, or arb-med-med. There's such a mixed range of dispute resolution processes. They're parallel processes, where we say, here's a financial issue which we cannot resolve in negotiation, but there's an agreed process here. This is going to go to that firm of accountants, of auditors, who will give us an authoritative view of that, the valuation of the business, while, for example, while we deal with other aspects, the interest-based aspects that we can resolve through negotiation or mediation. Or here's a crisp legal issue, discrete legal issue that can be resolved by expedited arbitration by a chosen arbitrator, while we also at the same time mediate the business aspects of it. I've been involved in that, and those things work. We can use mediation not just for dealing with disputes, but in deal making, especially more complex deals. Get a mediator involved from the start, obviously by agreement between the parties. And then, of course, there's always adjudication, arbitration, or litigation. If all else fails, always a first step when the case lends itself to litigation. Ultimately, the clients say, I want to control the process as far as I can. And as we go down that arrow from the top to the bottom, the client loses control as the process continues. And then, as a lawyer, you need to be multi-skilled. You need to be able to multitask. You have to wear different hats. And briefly, from my colleague and friend Jeremy Lack, this little scheme I like. It says, you can be a counsel to your client. You can be a problem solver. You can be a litigator. You can be an advisor. You can be all of those. What role should you play? Well, that depends on the task that is there a particular task, crisp, clear, discrete task that has to be performed. In other words, I want my money from the other person. And is there a relationship aspect that we have to consider? If the relationship concerns are low, and there's no particular discrete legal issue to be resolved now, then I'm in the role of an advisor. The client just wants some advice. I want to hand over my business to my children. I'm not sure whom I should appoint as CEO. That's typically an advisory role. If the relationship concerns are low, but there's a crisp legal issue, these bastards are stealing my copyright, my patent, infringing my patent, well, then maybe litigation is the way to go. If there's no discrete task at hand, no particular legal issue that requires urgent attention, but I need to find out from my lawyer, how can I deal with this tension at the board and in the family-owned business or in the practice? How do I go about integrating the people from the business that I've just merged with? That particularly is a counseling role where the lawyer is almost holding the hand of the client and guiding them to a solution that works for them. And then there's the lawyer as problem solver, where there are particular issues that you have to address, legal or otherwise, but there are also relationship concerns. And that is where you have a role to play as a problem solver, where you can say, look, there is a legal issue here, but there are other concerns, also relationship concerns. You want to keep the business link. You want to keep this marriage. You want to keep this relationship with the other party. Or even if the marriage is over, there are children involved. You will still have some relationship afterwards. What are the processes, options that we have that can give us a solution to the task, but also help us maintain whatever relationships we can and should maintain as best we can? And that is where you have a role to play. What can you do to become better equipped as a problem solver? Let me just see if there are questions. Elena, yeah, thank you. I see you clarified. E&E stands for early neutral evaluation. In other words, where you say to your client, look, we're not sure of our legal chances here, but let's use this particular expert. We pay them a fee and we'll refer the case to them, maybe as a stated case, or we will present the case to this person, and they will then give us an expert opinion about our chances of success. So early neutral evaluation, a neutral person evaluating the merits of your case. Jose, okay. Are there any E&E rules or framework, early neutral evaluation? Jose, I don't have any on the top of my mind, but you could just Google early neutral evaluation. You're going to find quite a lot of stuff there. And what you might also want to look at is EDR, early dispute resolution, where a lot of corporates now are saying we want disputes to be resolved as quickly as possible so that they don't escalate, because the danger lies in the escalation. The costs increase, the risks, the uncertainty, and the relationship damage increases if the dispute is allowed to continue. So how can I help my client with early dispute resolution processes as well? Okay. What would I recommend as a potential learning journey for you as young lawyers? Well, train as a mediator. Be trained as a mediator. Be trained also as a mediation advocate, because your role as an advocate in mediation is different from your role in advocate in litigation and arbitration. You're not looking at the legal niceties, the facts necessarily when you're acting as a mediation advocate. You're looking at the underlying interests. You're helping to create solutions that actually satisfy your client's interests. Improve your negotiation skills. There's a great book that a colleague and friend, Michael Leiths, has just written. Michael Leiths is the founder, director of the International Mediation Institute. He was corporate legal counsel for British American Tobacco, I think, for Unilever. A great guy. He's now retired, and he's just published a book which is aimed at corporate counsel. But it truly is a book that all lawyers should read, but also non-lawyers. And it's just called Negotiation, What Corporate Counsel Should Know But Were Never Taught. And it's published by, is it Kluwer? Wolters Kluwer. It's 1997, brand new, fresh off the presses. It's just called Negotiation, Michael Leiths, Wolters Kluwer. I really would strongly recommend that, because it's also practical and it focuses on effective negotiation skills. Include different alternative dispute resolution clauses in your client's contracts. Develop different fee models. Be creative. The hourly rate is part of our problem. There's no law, as far as I know, that says you must charge by the hour. Can't you think of creative fee models, not necessarily contingency fees, but fees for a particular project? If we can resolve this dispute quickly in this time frame and we can get this outcome, then this will be my fee, for example. And generally think of how can I provide a better service offering. But I think in terms of your skills development, it's negotiation training and training as mediators that can be of good use to you. And then let me just start ending off. Also something that Michael Leith wrote, based on the book by Susskind, comparison between the 20th century lawyer and the 21st century lawyer. And I will, through Giuseppe, provide you with these slides so you can look at this in more detail. But a very different character that we're talking about. The old style lawyer and the new style lawyer. And the message to you is that you can be that. You can be the 21st century lawyer if you're not already there. And let me leave you with a bit of wisdom from Gandhi, whom you know grew up in South Africa, where I was. I didn't grow up there, but he practiced law in South Africa for many years, where I'm from. And he was once asked whether, to what extent does he believe in litigation as a way to resolve problems. And this was his response. He says, both were happy over the result. He helped two people solve a dispute. Both rose in the public estimation. My joy was boundless. I had learned the true practice of law. I'd learned to find out the better side of human nature and to enter people's hearts. I realized that the true function of the lawyer was to unite parties driven apart by conflict. The lesson was so indelibly burnt into me that a large part of my time during the 20 years of my practice as lawyer was occupied by bringing about private compromises of hundreds of cases. And then the punchline, I lost nothing thereby, not even money, and certainly not my soul. Our time is up. Barbara, do you suggest some institutions or private entities where to practice as mediators? Barbara, you're from Italy. I can't, really promote any particular institution, but I think Google the institutions there. There is the ADR Center in Rome, for example, which is probably the leading organization in Rome by reputation, but there might be other providers as well. It's always a good idea to ask them for references and check people who have done their mediation courses to say how effective was this and how did it help you. By and large, though, your negotiation training and your mediation training combine to give you a better all-round negotiation skills, but also your negotiation skills improve your mediation skills as well. So these two tend to combine to give you a good rounded set of skills. Let me just look at my producer, Benjamin. I don't know if we've got time for any further questions. We can round off. If there are questions still, I've given you the bibliography there, which you will receive. And you're welcome to make contact with me as well. If there are particular questions or particular materials that you're interested in, I'd be more than happy to provide you with that. Barbara, somebody's typing. Just see. Okay, Barbara, you covered. Okay, well, if there are no further questions, I thank you very much for being for having logged in. Time flies when you're having fun. I didn't realize time was going so quickly, but thank you very, very much for participating. Go well, and wishing you all the best. Bye-bye.